Louisiana's lease termination laws operate under the state's unique civil law system, rooted in the Napoleonic Code rather than the common law tradition used by every other state. If you own rental property in Louisiana, this distinction matters because the terminology, procedures, and legal reasoning are different from what you'll encounter anywhere else in the country. Louisiana's lease termination provisions are found primarily in the Louisiana Civil Code, Articles 2668 through 2729, which govern the lease of things. Additional provisions are found in the Code of Civil Procedure, which governs the eviction process, known in Louisiana as an eviction proceeding or a rule for possession. Let's start with no-cause termination. For month-to-month tenancies, referred to in Louisiana as leases with no fixed term or leases reconducible on a monthly basis, either party can terminate by providing notice at least 10 days before the end of the rental period. That's right, just 10 days. Louisiana has one of the shortest no-cause termination notice periods in the entire country. So if rent is due on the 1st and you want the tenancy to end on the last day of the current month, you need to deliver notice by the 20th of that month. This 10-day window gives Louisiana landlords extraordinary flexibility to end month-to-month arrangements quickly. However, the notice must be in writing and should be delivered in a manner that can be documented: personal delivery, certified mail, or other methods that create a record. For fixed-term leases, the lease expires at the end of the agreed term under the civil law principle of expiration of the term. Louisiana does not require additional notice for the natural expiration of a fixed-term lease. The lease simply ends on the date specified. However, under the Civil Code's rules on tacit reconduction, if the tenant remains in possession after the lease expires and the landlord doesn't object, the lease may be considered renewed. For residential leases, tacit reconduction typically converts the arrangement to a month-to-month tenancy on the same terms. To avoid tacit reconduction, the landlord should provide written notice before the lease expires, making it clear that the lease will not be renewed and the tenant must vacate. For week-to-week tenancies, the notice period mirrors the rental period, so 7 days' notice is expected before the end of the weekly term. Now let's cover termination for cause. For non-payment of rent, Louisiana requires the landlord to provide a 5-day notice to vacate before filing for eviction. Under Louisiana Code of Civil Procedure, Article 4701, the landlord must serve a written notice giving the tenant 5 days to either pay the rent owed or vacate the premises. If the tenant pays within 5 days, the notice is satisfied. If the tenant doesn't pay or vacate, the landlord can file an eviction proceeding, called a rule for possession, in the appropriate court. Louisiana's 5-day non-payment window is relatively short and allows landlords to act quickly. The notice must be served by one of the methods authorized by the Code of Civil Procedure: personal service, domiciliary service, or certified mail. Proper service is essential because Louisiana courts will dismiss the eviction if the notice wasn't properly delivered. Here's something important about Louisiana's non-payment process. The state does not provide a broad statutory right of redemption once the notice period has expired and the eviction has been filed. In many states, the tenant can pay at any point during the court proceedings and stop the eviction. Louisiana's framework is more straightforward. Once the 5-day notice expires and the tenant hasn't paid, the landlord can proceed, and the court will evaluate the case on the merits. The judge has some discretion, but there's no automatic right to redeem by paying late. For lease violations other than non-payment, Louisiana's framework is rooted in the Civil Code provisions on dissolution of the lease. Under Article 2719, the lessor, the landlord, can seek dissolution of the lease when the lessee, the tenant, fails to comply with the obligations arising from the lease. The landlord must put the tenant in default by providing written notice of the violation and demanding compliance. If the tenant doesn't comply within a reasonable time, the landlord can seek judicial dissolution of the lease. The concept of putting the tenant in default is central to Louisiana's approach. Unlike states that prescribe specific cure periods, like 14 days or 30 days, Louisiana uses the civil law concept of mise en demeure, which is essentially a formal demand for performance. The notice must clearly identify the violation and demand that the tenant correct it. What constitutes a reasonable time to comply depends on the nature of the violation, and courts evaluate this on a case-by-case basis. For serious violations, including criminal activity, drug offenses, and conduct that threatens health or safety, Louisiana allows the landlord to pursue dissolution more aggressively. The landlord can argue that the violation is so severe that no cure period is warranted, and the court can order immediate dissolution of the lease. Louisiana courts recognize that certain conduct, like drug manufacturing or violent criminal behavior, destroys the fundamental purpose of the lease agreement and justifies immediate termination. Louisiana has specific provisions addressing drug activity on rental property. Under state law, a property where drug activity occurs can be subject to seizure and forfeiture proceedings. This creates a powerful incentive for landlords to act quickly when drug activity is discovered, not only to protect other tenants, but to protect the property itself from government seizure. One unique aspect of Louisiana law is the concept of lesion beyond moiety, which doesn't directly apply to lease termination, but illustrates how Louisiana's civil law framework approaches contractual relationships differently than common law states. The broader point is that Louisiana courts analyze lease disputes through the lens of the civil code, rather than through common law precedents, and landlords who are accustomed to the common law framework may find some of the reasoning unfamiliar. The eviction process in Louisiana goes through the city court, parish court, or justice of the peace court, depending on the jurisdiction and the amount in controversy. The landlord files a petition for eviction, technically a rule for possession, and the court issues a citation to the tenant. The hearing is typically scheduled within a few days to 2 weeks of filing, making Louisiana's initial court timeline relatively fast. At the hearing, the landlord must prove the grounds for eviction, whether non-payment, lease violation, or expiration of the lease term. The tenant has the opportunity to respond and raise defenses. Louisiana's eviction hearings are relatively streamlined compared to full civil trials, but the landlord must still present sufficient evidence to support the claim. If the court rules in the landlord's favor, a judgment of eviction is entered. The tenant then has 24 hours to vacate in most cases, though the court can grant a longer period depending on the circumstances. If the tenant doesn't leave within the ordered period, the landlord can request that the sheriff or constable carry out the physical eviction. The overall timeline from filing to removal can be as short as 2 to 3 weeks in straightforward cases, making Louisiana one of the faster states for the eviction process. Louisiana also allows the landlord to seek damages in the same proceeding, including unpaid rent, property damage, and attorney's fees if the lease provides for them. Combining possession and damages claims in a single proceeding saves time and legal costs. One thing Louisiana landlords need to understand is the effect of natural disasters on the lease termination process. Louisiana is one of the most disaster-prone states in the country. Hurricanes, flooding, and tropical storms regularly affect rental properties across the state. Under Louisiana Civil Code, Article 2715, if the leased property is totally destroyed by a fortuitous event, meaning an event beyond either party's control, the lease is dissolved automatically. If the property is partially destroyed, the tenant can seek a reduction in rent or dissolution of the lease, depending on the extent of the damage. These provisions have been invoked extensively after major storms like Hurricanes Katrina, Ida, and Laura. On the tenant side, Louisiana provides several grounds for early termination. If the landlord fails to maintain the property, as we covered in our Louisiana habitability video, the tenant can seek dissolution of the lease under the Civil Code provisions. the tenant must put the landlord in default by providing written notice of the deficiency and demanding repair. If the landlord doesn't comply within a reasonable time, the tenant can seek judicial dissolution. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Louisiana has several major military installations, including Fort Johnson, Barksdale Air Force Base, and the Naval Air Station Joint Reserve Base in New Orleans, making this provision relevant to a significant number of tenants. Louisiana enacted the Domestic Abuse Assistance Act, which provides certain protections for victims of domestic violence. While Louisiana's early termination protections for domestic violence victims are not as detailed as some other states, a tenant who has obtained a valid protective order can use it as a basis for negotiating early termination with the landlord. Some Louisiana parishes have additional local protections, and tenants in these situations should consult with a local attorney or domestic violence advocacy organization for guidance. Louisiana strictly prohibits self-help evictions. Under Louisiana Revised Statutes, Title 9, Section 3261, a landlord who removes a tenant from the premises by force or by shutting off utilities without following proper legal procedures is subject to civil liability. The tenant can recover damages and may be entitled to additional penalties. Louisiana courts consistently enforce the requirement that all evictions go through the judicial process, and landlords who attempt self-help face both financial penalties and the potential reversal of the removal. Louisiana does not have a comprehensive anti-retaliation statute comparable to what you'd find in more tenant-protective states. However, Louisiana courts have recognized that retaliatory evictions can constitute bad faith, and a landlord who terminates a lease in obvious retaliation for a tenant exercising their legal rights may face judicial pushback. Tenants can raise retaliation as a defense in eviction proceedings, and judges have discretion to consider the landlord's motivation when evaluating the case. One practical consideration unique to Louisiana: the state's legal terminology can be confusing for landlords who are accustomed to common law terms. The landlord is the lessor. The tenant is the lessee. Eviction filings are rules for possession. And the legal framework is based on the civil code rather than statutory landlord-tenant acts. Understanding this terminology and working with an attorney who is fluent in Louisiana civil law is important for navigating the termination process effectively. Louisiana requires landlords to return the security deposit within 30 days of the tenant vacating the property. The landlord must provide an itemized statement of any deductions along with the remaining balance. If the landlord fails to return the deposit within 30 days, they may forfeit the right to retain any portion and could be liable for penalties, including up to twice the amount wrongfully withheld, plus attorney's fees and court costs. Louisiana also requires the landlord to provide a written notice at the beginning of the tenancy, documenting any existing damage to the property. Failure to do so can affect the landlord's ability to make deductions from the deposit at the end. For the complete guide to Louisiana lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.